Good morning, Counsel.
Good morning, Your Honors. My name is Hayne Barnwell. I represent Joseph Nelson on his appeal. The evidence in this case must be suppressed because the search warrant issued without a previous proper oath in violation of Article 14. As a result, the purported facts supporting the warrant application were not properly sworn, such that probable cause was established.
Well, could you explain, you say it was issued without proper oath, and that's because they weren't face-to-face?
That is one reason, Your Honor. The second reason, and I'll quote Sergeant Lima's testimony, is that he took the oath after apparently the search warrant issued. And he testified as follows, and this is on page 36 of the motion transcript. Quote, Judge Healy had advised me to fax him the application for the warrant. He would review it. Subsequently, he faxed it back signed, or I signed it first, faxed it back to him, he signed it, and swore me in over the phone.
Doesn't that read as a clarification? I signed the last part being operative after the clarification. I signed it first, faxed it back to him. He signed it and swore me over the phone. But the "and" doesn't tell you. How does he know when it was signed and when it was sworn?
The way I read
it's just saying he knows he was sworn. He knows it was signed. That's all he can know.
The fact that he's saying subsequently, first, subsequently, I'm reading that in chronological order. But at best, the Commonwealth says that there's more than one interpretation for that testimony. So I would say at best that means it's ambiguous as to when he was
Did
sworn.
you raise this below? I mean, did you pick this apart and argue this very point that, this oath must have taken place after the judge signed the warrant? Was that what you were arguing below?
Well, defense counsel did raise before the hearing, because defense counsel wasn't sure how all of this took place either. Defense counsel said, I'm not sure, Your Honor, I haven't done any research on this, but can you swear someone over the phone like that? I thought you had to be in person.
Different
That's
question.
a different question.
But at the very least, it was in the suppression judge's thinking. He was thinking about the oath and whether the oath was properly administered. And I cite to Commonwealth versus Zerlong, which holds that this issue was before the judge, and he made an implicit finding in this case that the oath was properly administered. So I think it's probably before this court.
Let me ask you. Let's assume that Officer Lima had just lied in that affidavit. Okay, perjured himself. Could the Commonwealth not prosecute him for perjury based on the fact that that affidavit says it was given under the penalties of perjury?
I'm sure the Commonwealth could prosecute him.
So does the oath mean anything more than that it is punishable by perjury? I mean, what's that mean? Is the oath then?
Well, Article 14 says oath or affirmation. And I laid this out extensively in the reply brief, that an affidavit is not a substitute for the oath. And to take the oath, to go before the judge and raise your right hand and say all of the facts in my affidavit are true, and I swear to that. That is basically the critical foundation for probable cause. And the affidavit, while that is an added layer, it's an added protection for constitutional rights. I would call the affidavit the floor and the oath the critical foundation.
But the oath itself says it's on the pains and penalties of perjury. So what is the consequence of the additional oral oath above and beyond the written declaration that if I am lying, I am subject to perjury?
I cite a case, and I believe it's United States versus Shorter and then United States versus Richardson. And these cases talk about how the oath awakens in the officer's or the person's conscience the obligation to tell the truth, separate and apart from signing an affidavit.
But that was there as soon as he signed it under the pains and penalties of perjury. If he wasn't awake then, he wasn't going to be awake at any other time.
Well, I understand that point, but I still think it's different when you're face-to-face with a judge taking the oath, just like when a witness is about to testify.
But isn't your better argument that Chapter 276, Section 2B requires the person to appear personally?
Yes, and that also implicates Article 14, I do want to stress, because Article 14 states that that when warrants issue, they must be in accordance with the formalities of law. And clearly, Section 2B states unequivocally that the officer must personally appear before the judge.
Now, what do we mean by personally appear? Let's say they were on Skype. They were looking at each other in real time. How about that? Looking at each other really
that
right
is
through a
not-
screen. Not this case, but reality today can be done easily. Talk to each other, interact, see each other's expressions.
I don't think that's personal appearance, because I believe personal appearance is still physically showing up to a neutral place. And in this case, of course, the judge goes to a police station, which is not exactly a neutral place, and does this all by fax and telephone.
Well,
So
that's often where it happens in person also, over the weekend.
that it's in,
A police station.
In police station.
oh, a police station. I'm
Right.
sorry, I'm not aware, I don't know the procedures when it's, on call. But in any event, at least there's a direct contact, physical appearance before the judge, so that the judge can assess demeanor and credibility.
Assess demeanor by looking at someone through a screen as well. Certainly some of the capabilities today suggest that that can be easily done, and we often have trials in that fashion as well.
As far, are we back to Skype? Okay, well, if this is an issue about, you can see the person on Skype.
Yeah, is it seeing the person?
It's
Or is it
seeing
being
the person,
physically
but-
near each
but
other?
it's, it's also a problem of, even on Skype, it's still not a solemn, formal process which the statute requires, and the statute does not have any exceptions for, say, Skype.
Well, we put people under oath all the time in this process. We try people, long-distance trials are not unusual. People are testifying under oath, video.
But that's not what the statute, as far as I'm aware, the statute has no exception whatsoever. Video, fax,
Well,
telephone.
personally appear. What did they mean by that? What's the significance of that today?
Well, that's an issue of first impression because the legislature didn't define it. So what I did was I researched similar statutes in other states. So I believe in New Jersey, Illinois, and Mississippi. And they all have very similar statutes, and I believe all of them say personally appear. And they interpret that as you physically have to show up before the judge, take the oath, and that's that. So that's how I interpret it.
And do we know when that statute was first enacted?
I apologize, Your Honor, I'm not sure.
I mean, was it at a time in which there was any alternative?
It was in the 60s, I believe.
Yeah,
I believe it was the 60s. I think
64,
that's
so they
correct.
had
Before
telephone.
fax machines, but with
You're
telephone.
just
sure.
saying that it can be done, but it should be pursuant to a legislative change or a rule change to permit it.
Absolutely.
And absent that, we're really stuck with the language and our decisional law, which seems to suggest that this is something we have to abide by.
It
If
is.
I get your argument.
Yes,
Now,
Your Honor.
Why should that warrant suppression? We don't suppress every error. Why is this error worthy of suppression?
Well, first of all, the Commonwealth likens this requirement to a formality or a ministerial error, but I point you to Article 14, which requires that warrants follow the formalities of the law, which was not the case here.
Okay, but in Shepherd, the formalities of the law were not followed either, but we didn't suppress.
I believe I'm thinking of Pellegrini, and I did not take a look at Shepherd, but if unless I'm mistaken, correct me if I'm wrong, Pellegrini at least deals with, the judge did not sign the warrant, and that was a ministerial error, but the court took pains to point out that this should be the general rule, that judges sign warrants, but Section 2B does not require it, so we're not going to suppress. But here, it's personally appear, the language is clear, it's a substantial violation of 2B, and so therefore the exclusionary rules should apply just like the other states.
But
apply
going
the
back to your
exclusionary.
answer to Justice Cordy, you spoke about evaluating demeanor. I thought it was the four corners of the affidavit that govern. I don't know that a judge is supposed to be evaluating the credibility. The person often says nothing, just hands the affidavit to the magistrate or the judge.
That's true, but it's also, the personal appearance requirement it helps the judge at least assess demeanor. So if the officer
Because you can
shows
see the
up,
person has an honest face? I mean,
Well,
Don't they just want to know that it's the person who's
and
signed it?
Exactly, identity as well. So this is actually Sergeant Timothy Lima. This is, I see the badge, I see the uniform, just to make sure that this is all solemnly done. There's an original warrant for the defense counsel
Well,
to
does the
review.
statute require that the affiant be the person who appears before the magistrate or the judge? Can the chief of police get 5 affidavits and then attach them to an application for a search warrant, and then not in the chief of police not being one of the affiants, apply for the search warrant?
No, Your Honor, I believe the one who signs the affidavit must be the one who shows up.
Okay, so at least one of the affiants has to be there.
Yes.
Okay.
Yes. And the other thing I wanted to point out, I thought of 4 reasons why this is prejudicial to both Mr. Nelson and to the court system as well. First of all, citizens expect, and rightly expect, their privacy in their homes will not be invaded without police compliance with all laws. The second point is that there wasn't a proper oath, but assuming this court concludes there was a proper oath, formalities were still not followed in compliance with Article 14. The third thing is that this affects judicial integrity. We simply do not want judges associated with violations of law, such as Section 2B. It affects the process, but I think it also affects the neutrality of the judge. Again, the judge went to a police station at the time he was on a family vacation.
May I ask you, what should have happened here when the officer made the phone call? What should Judge Healy have said? I can't help you here?
I can't help you. Section 2B.
And so you've got to go find someone you can go and present yourself to.
Yes.
Physically.
Yes, and I want to point out that Sergeant Lima did testify that there was a judge on call in Roxbury who he had access to. He just apparently did not want to go. He didn't want to make the drive. And there are no exigent circumstances here. There's no reason why he couldn't have driven round trip from Roxbury to Stowe. He just chose not to do so.
would it matter if there, I'm sorry.
So when a judge is on call, they should expect that every application will come to them physically and present themselves?
Yes, under Section 2B, yes.
And, well, 2 things. There were 4 reasons, but you've only given 3 so far, so.
Okay, I was about to go to 4.
I'm waiting for your 4th.
And this court has already alluded to this, which is legislative integrity, that there are no exceptions to the personal appearance requirement. The legislature has determined that applying for a search warrant, it must be solemn, it must be a formal process. The affiant officer, again, has to physically appear, and that affirming the search warrant would basically render Section 2B a nullity.
Now, that actually is a perfect segue to the question I planned to ask after Chief Justice Ireland's. Let's assume there was an exigency. Would that matter, according to you? You just said there are no exceptions. So
There are no exceptions. I would have a tougher case, I suppose, in terms of prejudice, but under the statute, no, it would not change anything.
You know, I'm just thinking back to my experience in the juvenile court where judges routinely got calls in the middle of the night, early in the morning. They need a medical order from a judge instantly for a child's life or death. Of course, it's not a warrant, but it's authorization to perform extraordinary medical care, and it's routinely done by telephone because they don't have the time, the luxury of having the face-to-face. But a judge will order blood transfusions or surgery, and it's all done by telephone.
And presumably, the legislature has determined that those sorts of emergency circumstances are convincing to them enough to say, you know, you can do this by telephone. But here, Section 2B makes it difficult for very good reason. It makes it difficult for an officer to just get a search warrant.
Well, but you're not saying that the legislature couldn't change the statute.
They could change, sure. And legislatures have, I believe, after the Mississippi and Illinois and New Jersey decisions came down, the legislature amended the statute
And Federal
to fit
Federal Rule 41 allows that to
same.
happen.
Yes, but even if you have you allow the telephone facsimile procedure, there should be some safeguards here because for example, we don't have a transcript or a recording of the phone conversation between.
Well, you don't have
Sergeant
one in a
Lima.
live
We don't. But my point is, the federal rules require these sorts of safeguards so that we know that this is the person, this is the warrant, and it's being returned to the proper court.
We'll have to leave it there. Thank you very much.
Thank you, Your Honor.
May it please the Court. My name is Shirley Canton, and I'm a Special Assistant District Attorney from Middlesex on behalf of the Commonwealth.
How often does this happen? Is this now regular course, or is this just an oddball case where they couldn't find an emergency judge? And, I mean, is this unique, or is this something that is now being incorporated into the procedure, the search warrant application procedure?
Your Honor, I don't know how often this occurs below, but the circumstances in this situation were unusual, where a police officer was not able to get a hold of an on-call judge despite trying 4 to 5 times. And I would suggest to the Court that based on a fair reading of the record, Sergeant Lima testified that he wasn't able to get a hold of a judge in the area, and it's a fair inference that that judge he spoke to in Roxbury wasn't available to him.
Why is that a fair inference?
That's a fair inference because there wasn't anything in the record to establish that it was Sergeant Lima who was unable to make the trip to Roxbury. The testimony simply reflected that he wasn't able to get a hold of any judges that were available
If we were
to
to
him.
agree that it doesn't require face-to-face, to what circumstances would this be limited? Or would it then engender a phone call warrant from now on?
I would argue here where the search warrant comported with federal and state constitutional standards, where the warrant was issued by a neutral and detached magistrate based on sworn testimony that established probable cause, the failure of the affiant to personally appear, despite trying very hard to do that, does not constitute a substantial
So
violation.
you're saying that essentially it would write out a in-person requirement and that from henceforth you don't need that anymore?
The Commonwealth isn't asking this court to read personally appear out of the statute,
Well,
but
I'm asking you, how would you narrow it?
I would narrow it where you have a constitutionally valid warrant, where there is probable cause, where there is a record on which the defendant can later challenge the grounds on which probable cause was established, and where there's no blatant disregard of the law, that would be acceptable.
no.
That is reading it out. That is reading it out.
In what circumstances would you no longer require in-person affirmation or oath?
Well, I would argue
In no
that
circumstances
based
or
on the circumstances of this case, where there was a sworn affidavit signed to you under the pains and penalties of perjury.
So anytime you got an officer signing an affidavit, he can actually, and looking at the affidavit 4 corners and it's fine, then there's no longer a requirement to appear in person.
I think we need to comply with the statute as it's written, but on the facts of this case, where personally appear wasn't feasible for the officer.
So the way you would narrow it, if it's not feasible for the officer to personally appear, it's okay to call.
Where there's also a written record
I've got all that.
sworn to,
Yes, of course.
then I would agree with that, Your Honor.
So basically, it's the personally feasible exception to the rule.
And I would argue that
But
because
wouldn't that make it always the first option to use the telephone? We no longer have to go face-to-face. It's not feasible.
Well, I think one way to look at the question is a concern raised by the court. What is the purpose behind the personally appear requirement? And I would point the court's direction to the sample affidavit that's set out in 2B. And I believe the reason we require people to go before the judge is so that they can make an oath before the issuing court or the magistrate or the clerk. And here, Sergeant Lima's affidavit was signed under the pains and penalties of perjury, such that the first time Judge Healy considered the facts supporting probable cause, that statement was already under oath.
But that's true. I mean, every affidavit is signed under, in search warrant cases, is signed under the pains and penalties of perjury. So
I know that's the practice in Middlesex County. I'm not sure if that's the statewide practice. But if, again, Section 2B provides a sample affidavit and there is no signed under pains and penalties of perjury in the sample affidavit, thereby, I presume that's why the statute requires the person to go before the judge so that Sergeant Lima is who he says he is and Judge Healy is who he says he is. And there's no concern here where the motion judge made those findings.
I still can't get over Article 14 of our Constitution, which really says no warrant ought to be issued but in cases with the formalities prescribed by the laws. These are formalities prescribed by the laws. No warrant shall issue. Isn't that like a real fundamental right at the heart of our Article 14 rights?
And I would agree with that assessment, Your Honor, but here, again, we're not arguing that Sergeant Lima didn't comply with the law, but rather...
We are, but he didn't.
He didn't. He failed to personally appear. There's no dispute, but the question is whether that noncompliance constitutes a substantial violation of Section 2B, and the Commonwealth submits that it does not. Here...
You're saying it's a violation, but it doesn't warrant suppression, even though, arguably, it's not only in violation of the statute, but just as Justice Cordy said, it's in violation of the Constitution?
That's correct, Your Honor, and I would argue that substantial violations as held by this court in Commonwealth v. Shepard are violations that prejudice the defendant. Here, the defendant was not prejudiced where the affidavit was issued on ample probable cause, where there was an affidavit under oath such that the affiant would be subject to perjury penalties if he were indeed to have lied. Here, there's a written affidavit where the defendant can challenge the basis of that search because there is a preserved record.
So the rule going forward, if we agree with you, is you don't have to appear personally if you swear under the pains and penalties of perjury.
That's not what I'm arguing.
No, but that would be one of the rules if we agree with you, wouldn't it?
I'm arguing that in limited...
But that would be one of the rules if we agreed with you, wouldn't it?
Assuming that the warrant is constitutionally valid, assuming that there's a record on which the defendant can later challenge the basis of his search, then I would argue that failure to personally appear in limited circumstances is not going to be a substantial violation in violation of Section 2B, and certainly does not warrant exclusion of the evidence. I would argue that this court numerously has held that even violations of a constitutional magnitude don't necessarily require suppression. As this court has stated, the purpose of the exclusionary rule is to deter police misconduct. Here, frankly, there was no police misconduct to deter. Sergeant Lima testified that he tried to get a hold of the on-call judge 4 to 5 times, only to be told by each that they were not available. The testimony suggests that where the sergeant made diligent efforts to comply with Section 2B, that really there is no police misconduct.
Now, I gather we have no finding by the judge as to whether there was exigency here, correct?
That's correct, Your Honor. And I would argue that just because there wasn't an exigency such that Sergeant Lima shouldn't have just barged in without a search warrant, that doesn't mean he could have afforded to wait until Monday to execute a search warrant.
No, I'm referring to exigency, meaning no judge truly available for Lima to go to that judge's home or to a place in that judge's community to get the warrant.
Yes.
So we don't really know. I mean, we know what he testified to.
Yes, that's correct.
And he said none was available, meaning he couldn't reach any of them, or?
I think the testimony in the suppression hearing was that he would call on-call judge after on-call judge with the state police, only to be told by each that they were not available. He spoke to a Roxbury judge, but the testimony was that he couldn't find a judge he was able to access. And I think a fair inference is that just as a defense counsel suggests that he wasn't willing to make the trip, an equally likely reading was that that judge wasn't available to him.
What about the clerk magistrate of the court where the...
That's not in the record, Your Honor, but again, based on Sergeant Lima's 20-year tenure as a police officer, I would argue that we can assume he made a good faith basis to reach the clerk and that she also was not available. But again, that's not in the record.
Was this, Ms. Barnwell addressed this a little bit, but at the motion to suppress hearing, how big an issue was this?
Well, the motion to suppress was a boilerplate motion based on lack of probable cause. This all came out at the motion hearing. But again, the timing of the oath, all of this wasn't a live issue, certainly with respect to the timing of the oath. But the motion judge...
Not the timing of the oath, but, for example, whether, the issue whether the clerk, in other words, was the defendant saying there's been no compliance with procedures so that one would have expected some questions about whether the clerk magistrate was or wasn't available. I mean, I'm trying to figure out, because a lot of, the record is silent on a lot of facts that one would want to know.
Your Honor, these issues were not pressed below. There were not factual findings made by the motion judge why he couldn't go to Roxbury or whether the clerk magistrate was or was not available.
Well, did anybody even know that this had happened until the motion to suppress hearing?
Well, certainly the defendant was on notice that this entire procedure occurred over the fax and telephone because
How did he know? How is that apparent from the record?
that is apparent from the record because the signed affidavit, Judge Healy crossed out that portion of the jurat stating, and the person appeared personally before me and made oath. He only endorsed the part that occurred, which was Sergeant Lima had made oath before him.
And it showed also it showed that it was a fax, right? I mean, did
Yes.
the physical piece of paper?
The physical piece of paper had the Stowe Police Department and the New Jersey Police Department's telephone and fax numbers, as well as a time record. I would also argue to the court that the other cases that the defendant have cited in other jurisdictions, the warrants there were issued only on oral testimony where there was no contemporaneous recordation of what had happened. Here, there is an affidavit submitted to under the pains and penalties of perjury such that the defendant can challenge the basis for the search based on the four corners of the affidavit, which is in accordance with Massachusetts procedure.
So you're saying this was not argued below?
Which portion, Your Honor?
The
in-person?
The fact that he did not appear personally before the
It was
judge.
argued, and the judge made explicit findings that while this procedure was certainly unusual, at the end of the day, the search warrant comported with federal and state constitutional grounds, and that what the officer did under the circumstances was reasonable within, the boundaries of the constitutional standards, and therefore there was a valid search warrant.
What about the return problem, out of curiosity? The warrant wasn't returned for months?
Your Honor, I would like to clarify that the inventory listing the items seized and the affidavit bearing both signatures was returned in a timely fashion. It is
That's
only
in the record?
Yes, that is in the record.
January 24th or something?
I'm sorry, that was returned in a timely fashion within either the 3 or 7 day standard. It is only the face of the warrant without the signatures that wasn't returned until the motion suppression hearing. And the reason for that is because of the fax procedure, the original back of the search warrant was returned, but the faxed copy, which the judge had signed, wasn't returned until the suppression hearing. And I would point, and as this court is aware, the SJC has repeatedly held that failure to comply with the warrant return procedure is a ministerial error that does not warrant suppression of the evidence. And I would point the court's attention to Commonwealth versus Ocasio on that point. So for all of these reasons, where the search warrant comported with federal and state constitutional standards, where the failure to personally appear in this case before the judge as required by statute does not constitute a substantial violation, I would argue that there is no basis for exclusion of the evidence.
Thank you.
Thank you.